Hello, welcome to the webinar today run by LegalVision. We're talking today about sponsoring foreign talent for your new tech startup, and we hope that you enjoy this seminar. My name is Yin Chiew. I'm the practice leader in the corporate immigration team, and my colleague Kaku Caro, who is a lawyer in the corporate immigration too, will be your speakers today. So before we begin, you will be emailed a copy of this webinar, a recorded presentation and the slides. If you have any questions, feel free to submit them in the chat box. And we would really appreciate it if you could complete the survey at the end of the webinar. We do offer a complimentary consultation to attendees that want to talk about how they can sponsor foreign talent for their new tech startup. So if you're interested in that complimentary consultation, please leave your contact details at the end of the survey and we will get back to you. So the reason why we wanted to do a webinar focusing on tech startups and sponsoring foreign talent is that LegalVision has had the wonderful opportunity to work with so many innovative startups across all industries, and a lot of them have been tech startups, and we've been privileged to see them flourish and grow. And part of that growth strategy has been around acquiring or obtaining and attracting the right talent. And as you are aware, with the shortage in labour skills across Australia, most of those types of skills and talent is in an offshore capacity. So today we'll be talking about, well, how do we assess a tech startup's eligibility to become an approved sponsor? What are some of the challenges that as a new business that you could face sponsoring workers, how to mitigate some of those challenges? And then once you sort of gone over the threshold and become an approved sponsor, what are your obligations and implications of sponsorship? And then some examples or some visa options that you may consider as an approved business sponsor, or independent visas that may be suitable for some of the talent that you're looking to source for your business. We'll have some time at the end of the webinar for a question and answer section as well. So we can move on to the next slide. So in assessing your eligibility to become an approved business sponsor, that's typically the first step in the immigration process, is that you would need to apply to become what's called a standard business sponsor. And that can be challenging for some businesses, particularly tech startups, when they have to demonstrate things like, well, we've been legally established, we've been actively operating for a period of time, there is no adverse information known about us. We have to observe sort of market salary requirements. We have to show that we have a track record of employing workers, and this may be difficult if you don't have a workforce. Well, we have to show a track record of employing workers, that we haven't engaged in any discriminatory recruitment practices, that we have to identify an appropriate position or occupation, often from a very set list of occupations as well, and that we're also financially stable and sound. And this could be through revenue or capital raising. So these are sort of the requirements that need to be demonstrated to be eligible to become an approved sponsor. But as we said, these are very complex situations with a tech startup, in that most of these types of businesses have just been recently incorporated, or they have only been operating or trading for a short period of time, in some instances less than 12 months. There isn't any revenue. There isn't any client base. Maybe the product that you're refining or testing is not ready for the market. It's not ready for commercialization yet. Maybe you're bootstrapping. There is very minimal startup capital, or you haven't yet pitched to external funders for further capital, or you're in the process of doing that. Maybe the position or the skill that you need is very undefined because it's highly niche and it's not readily available in Australia. And it's very unique to your particular tech startup business. Maybe you're having difficulties attracting the type of talent or skills that you need. And maybe you have sort of a workforce profile of offshore contractors that has kind of worked for you up until a certain point of time. If we can move on to the next slide. So there are also additional challenges, and these are more sort of from the commercial perspective and even the practical perspective as well, such as, you know, it can be challenging and a little bit complex to navigate your obligations under immigration law, what the process is, what's required, where do you even start as well. And obviously this is where we come in to assist you. There's also high competition. If you're a new startup, you may know of other competitors. There may only be a very small portion of skills in the market in Australia, and even less across the world, that you're looking for. So the competition for this type of talent is high, and the way you have to attract that talent needs to be quite unique and specific to your business. And as a new business, it may be difficult to do that, as you may feel like you don't have a lot to offer at this stage. There may be some also limited visa options for your business at this stage if you're not able to pursue the sponsorship route. There's also significant costs that as a startup you're very careful around. Most startups will often bootstrap, will minimize certain administrative costs. So the cost of sponsoring a foreign worker is quite large as well. And then the timeframes taken to actually commence this process could be long, could be exacerbated, things like that. So we can move on to the next slide. So how can you mitigate some of these challenges? There's definitely some practical approaches that you can take. And a lot of that would be, speaking to us or, a migration advisor and lawyer around what you need to do as a business to get into a position where you're able to sponsor foreign workers. So if capital is an issue, you may want to wait until you receive external funding. You may want to spend more time refining your product, getting it to a minimum viable product level, and that it's ready for commercialization. You may need to redefine or even, refine the particular skill, position, occupation that you're looking for. And you may want to access sort of the foreign worker population in Australia that may be on other work visas that don't require sponsorship, such as working holiday, student visas. And there are options to potentially bring overseas workers to Australia on another work visa, which Kaku will talk about a little bit later, that doesn't require sponsorship, but merely an invitation. Now, there may be other pathways too. There may be other practical steps that you can take before you go down the route of sponsorship, which is, maybe, relying on your offshore contract workforce for a period of time. Maybe you'll work with a recruitment company that has an on-hire labor agreement, and they're the ones that actually sponsor them and on-hire them to your business. So you can at least build up your business a little bit more before you go down the route of sponsorship. And, obviously planning is a big part of it as well, is, planning for these costs. If these types of skills are really needed in your business and the range of options discussed above is not an option anymore, then it's really just making those plans as well. I'll just move on to the next slide. And now I will hand the presentation over to my colleague, Kaku Caro.
Fantastic, thank you, Yin. So in considering what are the options to actually sponsor and nominate foreign migrant workers, you're currently seeing the standard application process. So For the visa subclasses 482, the temporary skills shortage or TSS, or the visa subclass 494, the skilled employer regional sponsored visa, it's a three-step process. So your tech startup must apply for standard business sponsorship status, or SBS for short. And this sponsorship status lasts for 5 years, and it allows your tech startup to actually consider sponsoring foreign workers via these two visa subclasses, the 482 and the 494. These are temporary visas. They might lead to permanent residency down the track, but it is a great starting point to bring foreign migrant workers and allow them to work for your business, be in Australia, settle for a couple of years, depending on the visa duration. Now, the step 2 and 3, as you can see, it's a nomination application and a visa application. So if you can think of the nomination and visa applications as two sides of the same coin, they are paired by the Department of Home Affairs, and they look at various different things. They look at the salary, they look at the genuineness of the occupation, if it's an eligible occupation for sponsorship purposes. They look at the skills of the migrant, education, work experience, the skills in that particular occupation that they can demonstrate. And it is important to note that these nomination and visa application must be lodged each time per sponsorship of a foreign migrant worker. Now, obviously, we have the permanent residency counterpart, the 186, via the employer nomination scheme. And this is why we say sponsorship and nomination. So the nomination for permanent residency, again, it's a two-step application. It's a nomination and a visa application. There is no need for standard business sponsorship. However, it is important to note that throughout all of this entire process for both the standard business sponsorship or nomination for permanent residency, all the key challenges that my colleague Yin has mentioned before are crucial. You must demonstrate that the business is viable, it's been operating, it's been established in the market, it either has revenue income or it has a lot of capital raising to back it up in order to demonstrate that it can substantiate and basically maintain the positions and pay the salaries. So if we can move on to the next slide, we'll show how the process looks in this flow chart. So as you can see, the very first step at the top, the standard business sponsorship application by the business. For the visa subclass 482, the business must lodge the nomination application, whilst the applicant must lodge the 482 visa application. And the same applies for the 494 regional visa. So moving on to the next slide, we wanted to show a few examples of what are the occupations, what visas those occupations may allow to consider, the duration, and obviously a few of the requirements that you can have a snapshot of the entire process. So if you can look at this graph, at this chart table from left to right, the first column, the occupation, this is essentially where we begin in our assessment. It's very important to assess what position you're trying to fill, what position you're currently experiencing shortage that you cannot fill with the local Australian market. There is a set and rigid defined of occupations via the ANSCO, Australia New Zealand Standard Classification of Occupation, which operates as a job dictionary. And this is what the Department of Home Affairs uses. So once we have found the specific occupation, we can then consider, okay, what are the visa options that the business can consider for sponsorship or nomination? We have the 482, the 494, and the 186 for permanent residency. We have outlined a few key ANSCO occupations already for you, which in our experience, we have seen tech startups that usually need early on. Now, each visa will have different durations, either maybe temporary or permanent residency. If it's a temporary visa like the 482 or the 494, it might lead to permanent residency down the track. And we have outlined key sets of work experience and age requirements, which you can explore later on when you have access to these slides. So we can move on to the next slide. It is really important to note that applying for standard business sponsorship And sponsoring workers on the 482 and 494 visas, this will attract obligations which the business, your business must abide by. So a few of these, for example, it's notifying the Department of Home Affairs when certain key changes occurs, such as changes in employment circumstances, changes to the business address. You must notify the Department of Home Affairs within a specific time frame. So that's very important to note. Next is salary obligations. So your tech startup must pay the sponsor worker at least the market salary rate or the salary agreed upon in the employment contract, whichever is higher. You may have seen recent developments when it comes to the threshold, the income threshold for immigration purposes. It will rise to $70,000 from the 1st of July. So if the salary, your proposed salary is anything below 70,000, just please keep that in mind as well. Obviously, you must keep all your records because if you are audited and they would like to see some of those records, you have to produce them. So key to maintain timesheets, employment contracts, pay slips, make them available. Also, if you are audited, you must cooperate with the Australian Border Force. You must cooperate with inspectors. You must provide access to the premises, records, and you must answer all questions truthfully. The last two is the nominated occupation, which is quite important. So in the previous slide, as you have seen, if you nominate a specific ANZC occupation, you must ensure that the sponsor migrant worker works only in that nominated occupation. This might be quite a challenge early on for tech startups because you might need certain people to perform various sets of roles. So that's quite hard to obtain from this particular visa frame. Now, the last one is the application cost. So you must not recover any cost from another person or the applicant in terms of the standard business sponsorship application and the nomination application. You can cover costs in terms of the visa application. And it is important to note that this is not an exhaustive list as well. There are various other obligations in line. And obviously, important to consider that failure to comply with any of these obligations can result in hefty fines. It can even result in the cancellation of your standard business sponsorship status. It could result into a bar from sponsoring or nominating any future migrant workers, which can be crucial for your tech startup, in particular with the aspects that my colleague Yin has mentioned. There's a skilled labor shortage, particularly in the IT and tech field. So this is also quite important to bear in mind. Now, my colleague Yin will mention about labor agreements. Thank you, Yin.
Thanks, Kaku. Appreciate that. It is quite a lot. We understand there's a lot to consider here in sponsorship, the sort of pre-assessment aspects of, is your business even eligible? Then once going through the process and becoming approved, there are obligations that you would need to comply with in respect to obligations to the Department of Home Affairs and the sponsored worker. And then there's a process in relation to which visa subclass that you'd need to go down. But we're here to help you navigate that. And, if you're well informed and aware of the situation, there's a lot of tools and process that you can put in place to ensure that you're on top of all your obligations. Another option is labor agreements, and they are typically for businesses that can't identify an appropriate ANZCO occupation from the skilled occupation list in relation to the visas that Kaku has explained, the 482, the 494, and even the 186. And it's quite common that some of the positions or occupations or skills that you need are so niche that it's not identifiable. So we can move on to the next slide. What is a labor agreement? A labor agreement is fundamentally a contract between the Australian government and the Department of Home Affairs and the Australian business. So it would be the tech startup business, or it could be any other business that may need to access a visa or immigration pathway that is not readily available under the standard employer sponsorship or employer nominated pathway. But it is a contract. You do typically need to put forward a very extensive business case. There are different streams of labour agreements. There's industry-specific labour agreements, there's company-specific labour agreements, and then there are sort of regional agreements that are known as designated area migration agreements. That they are also labour agreements too. And they can kind of sit in parallel with a business's sponsorship approval status. You can be an approved sponsor, you can have a labour agreement, you can have a DARMA, if that's essentially what your business needs as a tech startup, and even a range of other businesses as well. But it does allow the Australian business to utilise existing visas such as the 482, 494 and 186, but under that labour agreement arrangement. So there will still be sponsorship obligations that you will need to comply with. As a result of that labour agreement, it does allow you to sponsor a specific number of workers per operational year. So this is where there is actually a limitation to the amount of workers you can sponsor under labour agreements. But the benefits of a labour agreement at times can be there can be concessions or variations to the terms in relation to English, skills qualifications, salary component as well. If we can move on to the next slide. So there are some key considerations with the labour agreement in that it's not an application. There is an official form that you would have to fill out, but it's actually a request that is sent to the minister's unit, and they are the ones that assess labour agreements. It is also approved for a period of 5 years, but it starts from the date that it is mutually executed by both parties. There are ways to vary the terms of that labour agreement through a deed of variation. So over the operation of that agreement, the business can submit a deed of variation and request changes to it. It's typically not available for businesses that have been in operation for under 12 months. So if the tech startup is newer than 12 months, then that's probably not an option. But we will talk about another labour agreement that may be suitable for a tech startup. But for tech startups, we know can operate, less than 12 months. They could be, more than 12 months. So if that's the case, a labour agreement could be suitable too. I must stress that in the request, the labour agreement request, there needs to be a submission of a very strong business case and ample supporting evidence as well. If we can move on to the next slide. So we've provided this flow chart as well to show you how the process works. It is utilising existing visas, but it will be on the terms and conditions outlined under the labour agreement. And typically the deed of variation can then change the number of workers you want to sponsor, can then allow for pathways to permanent residence, and there may be some amendments that can be made to the requirements, such as the salary, the skills qualifications, English requirements, things like that. If we can move on to the next slide. So the Global Talent Employer Sponsored Labour Agreement is another labour agreement, and there is a particular stream called the startup stream that would be suitable for tech startups or businesses that operate in the STEM industry. Excuse me. So with the startup stream, it does allow sponsorship of up to 5 individuals, or 5 positions can be nominated. It does require endorsement by the GTES Startup Advisory Panel. And there is some form of visa flexibility, such as it would allow you to sponsor someone on a 4-year 482 visa. And there will later be a pathway to permanent residence for those workers for you. So we can move on to the next slide. So I'll hand it back to my colleague Kaku, who will discuss with you independent visa pathways.
Fantastic. Thank you, Yin. So obviously, aside of the visas that I will shortly discuss, I thought it was an opportunity to mention that you could potentially continue relying on, for example, student visa holders to work for your business. You could potentially rely on working holiday visa holders as well. You could potentially rely on various other visa subclasses. But what I would like to focus on today is on three particular visa subclasses. So the first one is the highly specialist skilled visa, subclass 400. It is a great option and alternative to either of the standard business sponsorship or labor agreement, 482, 494, and 186 subclasses. And this is because it allows your business to endorse, not to sponsor. It's more of an invitation. The applicant will actually lodge the 400 visa themselves, and they must show that they have highly specialized skill set and that they will work for an Australian business in a project work that is non-ongoing, it's short-term. So you must demonstrate that this particular highly specialized professional is coming to Australia to work in a defined project to then return and go back to their home country. And the great benefit of this visa is that this particular project could be the setting up of a particular service, of a particular process that needs to happen internally. Maybe it's a trade project. There's an installation of an electrical grid, or that you need a particular professional for your tech startup to assist onshore because of obvious risk reasons. You need someone onshore for security purposes to protect your data. There's no application required. It's a single visa application. We must point out that this application must be lodged offshore. This particular candidate cannot be in Australia. However, the processing times can be rather quick. Obviously, if things do change and your business becomes eligible to consider the standard or labor agreement sponsorship pathway, obviously you could consider lodging a 482 visa onshore. That's a potential avenue as well. Now, the next visa that I wanted to mention it's two subclasses actually. It's the 189 and the 190. Now, these two subclasses are permanent residency. They're independent skilled visa options, and they actually require an expression of interest invitation. So we label these visas as invitation only. Additionally, they must demonstrate that they have a skilled occupation in the eligible occupation list. They must demonstrate that they have, it's a competitive visa framework. So they have to show that via a points test that they have a high amount of points, higher than 65, preferably going to 85 and 90 points via English level, education, work experience, maybe partner skills as well. And if they have high enough amount of points and they do get invited, they can lodge the visa application. And that's another excellent pathway. We are seeing that STEM occupations, IT and tech field, all of these are excellent candidates for these two visa subclasses. So if you do have a close relationship with an overseas professional and you would like to work together in your tech startup, you could consider these two visa options. Absolutely. So moving on to the next slide, please. Last but not least is the global talent visa. Now, these operate separate from the global talent employer-sponsored labor agreement stream, startup stream. This is an independent visa as well. It may require invitation. You also have the distinguished talent stream. Now, with this particular visa subclass, the candidate, the visa applicant, must demonstrate that they have an international recognition in a particular target sector, that they have outstanding achievements. It may be publications, it may be featuring in the media, articles, it may be presenting in conferences, discussing topics, having that public recognition. they must also secure nomination by an Australian organisation or individual that's equally established and has that recognition in a particular target sector as well. It could be considered, applicants could be considered up to 55 years of age if they can demonstrate, that exceptional economic benefit to Australia. And this is additionally a great pathway for working with skilled IT and tech professionals to work together with your tech startup if the other visa subclasses could not be considered as well. So, these three independent visa subclasses, could work in your favor. This is a lot of different options, so it does require strategizing, and that's also what we can bring to the table and how we could assist your tech startup is looking at all these different visa options and working closely and what is the best next step and how we can get your business to that position to simplify and streamline all of this process. Now, that concludes the main part of the webinar today. I invite you to find our publication, Employer Guide to Sponsoring Foreign Workers, that you can find available by scanning the QR code or by accessing them via the slides later on. You can find it for free in the handout panel. Now, we also have an upcoming event that could be of your interest. It is Selling a Business, What to Avoid in Your Sales Contract. It is scheduled for Thursday, 11th of May at 11 a.m. Australian Eastern Standard Time. Please feel free to register in the hyperlink that you see on the slide. So we're going to be answering questions shortly, so please feel free to submit them. And while you submit your questions, I'd like to take a minute to discuss our membership and to tell you more about it. So part of LegalVision's unique legal services is that we offer a membership that is cost effective. It's an alternative to the expensive hourly rates that you may experience with other law firms. It's an affordable option for a monthly fee. You received cost certainty and all-inclusive legal services for your business as usual needs. So a few of these examples could be unlimited document review. It includes drafting, amending, reviewing business contracts, service agreements, commercial leases. It also includes unlimited advice consultations. You can very easily schedule a meeting with our team of 100+ specialist lawyers. It includes business structuring, employment, corporate immigration queries, disputes, and many more. It could also include unlimited domestic trademark registrations. And it also gives you the opportunity for unique discounts of corporate immigration applications, such as sponsorship. Now, to learn more about membership and how we can help you, definitely request a free consultation with our team when the survey appears at the end of this webinar. So we'll move on with answering some of your questions. Our colleague Yin will begin with a few of the questions that we have received.
Thanks, Kaku. So I know there's a lot that we covered today, and obviously, if there are specific questions unique to your business, feel free to schedule in a consultation with us. It's complimentary to talk about, well, is your business eligible to be a sponsor, and what would be the process for that, or what would be the options available. So I'm going to answer some questions now. We've got quite a few, which is fantastic. So thank you for that. The first question that we have, and excuse me as I look through that question, it is there a limit to the number of people that you can sponsor? And this particular question, they've said we are on our third sponsorship and we only have 3 employees. So if you're approved business sponsor, so standard business sponsor, there isn't actually any limit to how many people that you can sponsor. And as you are aware, each sponsored worker that you want to hire, you will need a nomination and a visa application. So it's really just about, can you demonstrate all the criteria in relation to each of those applications for each sponsored worker? And if you can, and then there is no limit. Now, under a labour agreement, there is actually a limit, and that's specified in the labour agreement. There will typically be a number of nominations, or what's called a nomination ceiling, of approved workers that you can sponsor per year. And this is often, what you would submit in the labour agreement request. And provided that the minister's unit deems that to be reasonable and appropriate, that's typically the number that you are able to nominate per operational year. It's not uncommon for some of those figures to be in the vicinity of like maybe 5 to maybe up to 10 for a business on being approved for their first labour agreement. It is then possible to submit a deed of variation in the next operation year and increase that nomination ceiling, and sometimes that doubles and possibly triples as well. But typically with that deed of variation, you have to put forward a very extensive business case to explain, well, why do you need that increase in nomination?
Very detailed answer. Thank you, Yin. So we do have another question. We are looking at how to bring in talent from overseas. Would be great to understand what the requirements are. So this is obviously quite a broad question, and many of the topics that we have discussed today, definitely apply. However, what I would like to answer this question is just to propose how we can help. And what does the process look like from start to finish? So obviously, please do request a free consultation with us so that we can discuss what does your tech startup look like today? What is the current situation of your commercialization, your product, your service? What is the kind of revenue? Do you have capital raising? And what does your workforce look like? And then based on that, the next step would be really understanding the position, the roles. We would need to have a deep look at the position description document to understand the tasks and duties, so that we can work together and find the most closely related ANSCO occupation, so that then we can see, okay, is the occupation in the eligible skilled list? And then what are the visa options that we can consider? Is it sponsorship via the 482 or 494, or is it permanent residency nomination via the 186? We will also discuss, obviously, the commercial decisions behind that option as well. And then if everything goes well, we will guide you through the nomination and visa application process. We would have to look at the specific candidate that you have in mind. If you don't have a candidate, we can also coach you into what the process would look like regarding your potential job advertisements to try and find local workers or to expand your search overseas as well. And then obviously we commence the actual process, which tend to take 4 to 6 weeks, give or take. Obviously, if the business is not in a position to proceed, we can discuss the other options such as labor agreements, the global talent employee sponsored startup stream, or any other independent visa options that can help you into bringing those highly specialized workers onshore. So as you can tell, a lot of different steps, but the very first step that we would encourage you to take is just to reach out to us so that we can discuss your current situation and how we can assist.
Thanks, Kaku. And we have another question. That question is, I want to actually hire a migrant worker, but I want to nominate them for permanent residency. And so that's a really good question, because often we find with our clients, established businesses, startups, tech startups as well, they don't necessarily want to go through the process of actually, becoming an approved sponsor. They don't want to actually, sponsor someone for a temporary period of time. That they actually want to actually employ a foreign worker for a permanent period. So we have definitely worked with quite a few tech startups where, again, they're faced with those types of challenges that we talked about, very little revenue, very minimal clients, still working on the product, reliant on capital raising, potentially operating at a loss as well, where they have wanted to nominate someone for permanent residence straight away. The skill set was very important to their business, and And fortunately, we've been successful in that. And often the key issue here from a Department of Home Affairs perspective is, can that startup business financially support the nominated salary for a period of 2 years? And that can be difficult to explain or to evidence for a very new startup business, but we understand, or we know, that startups operate in different phases as well. So it may be difficult for a very, very new tech startup that has really only been in operation for less than 12 months, but a tech startup that has probably been in operation for maybe about 3 to 5 years, which is maybe the second stage, and they've done their first round of capital raising, such as a Series A or pre-seed round, they may still be able to nominate a foreign worker for permanent residency straight away. And I think that's all the questions that we have so far. So thank you so much for joining us today on this webinar. And again, if you have any further questions or you would like to arrange a complimentary consultation with us, please indicate that at the end of the survey and we'll definitely be in contact with you. And please feel free to download our publication, The Employer's Guide to Sponsoring Foreign Workers.
Fantastic. Thank you so much for joining us. We would appreciate if you can complete the survey at the end of this webinar. It usually takes about 30 seconds to complete, and also you can request that complimentary consultation. That is all for today. Thank you for joining us. Thank you for watching. Hope you have a lovely rest of your day.
Thank you. Bye.